about some legislation.
Sounds good.
All right, it's been a busy year, and we have another piece of pending legislation to talk about. The Veterans Appeals Efficiency Act of 2025, also known as H.R. 3835, is currently being considered by the House of Representatives. Last I checked, it had made its way to subcommittee hearings, and those hearings were held at the end of June. There's a companion bill in the Senate. I think it's S 1992 or something like that. You can look it up. That's just been referred to subcommittee hearings. So this is nowhere near finalized. It still has to go to committee. It'd have to come out of committee. There'd likely have to be reconciliation between the House and the Senate if either chamber passed that version. So this is all
long ways away.
Long ways away.
Yeah.
However, we do want to get ahead of it, talk to our viewers about what this legislation means and what it's proposing to do, because as we've reviewed it, there are some great things, some things we really like in the legislation. And then there are some things that we really do not care for and don't think are going to help the veterans that we serve and veterans writ large. So let's dive into some of the proposals, Mike. So first, it proposes some annual reports on claim timeliness and appeals dismissals, like that.
Yep.
Like more reporting, like insight into what's going on in VA and what our clients can expect. So more reporting, more transparency, that's great. Speaking of transparency, it also talks about making how claims get expedited at the board more transparent. What are the actual rules for expediting your appeal at the board? We know some of them, right? But what is the board actually doing to expedite? How do you end up on that expedited list?
Again, no problems there probably, right?
Yeah, no, completely on board with that. And it also recommends some technology upgrades for VA to track remands. How many times is a case being remanded from the court to the board? How often is a board member following that remand instructions? It would be nice to have that
information,
right?
wouldn't it?
Absolutely. So we are all for those types of proposals.
But, I think the second part of this is that the bill is filled with good intentions, but really significant risks.
Absolutely.
Here at CCK, we of course support faster, smarter decisions and overall adjudication. But it has to provide fair decisions to veterans, and it has to overall benefit veterans.
Right.
Two areas of the bill in particular that are significant risks or raise significant red flags to us here. The first being claim aggregation without the proper safeguards, which we'll talk about, of course. And the second is expanded judicial authority for the Court of Appeals of veterans' claims.
Right. All right, so let's talk about that claim aggregation without opt-out provisions.
Yep.
So the piece of legislation proposes that the Board of Veterans Appeals chairman can consolidate appeals with similar facts, questions of fact, or questions of law, and decide that shared issue in one go. It sounds efficient.
Sounds good,
It
right?
sounds great. Like we have, 5,000 appeals. They all pivot around this one question of law, what is the standard in a VA examination for aggravation? Is it permanent worsening or is it something else? Or a question of fact, were veterans at X location at X time frame exposed to chemical X? So those questions, it sounds efficient. However, it could delay complex claims with very obscure medical details. It risks maybe a weaker case affecting a stronger case if the facts aren't so great in one case but really strong in another. How's that going to shake out? And it introduces confusion at hearings and evidence submission. How is a veteran going to know that they've been opted into this? What notice requirements are required by VA to tell a veteran you've been combined in this appeal? There's just so many hurdles in the way to making this a good process for veterans that just doesn't seem great. Now, the one instance in which I could have seen this being helpful, and it's way too late for that, was pre-PACT Act.
Sure.
When we had how many veterans of the Vietnam War who served in Thailand fighting day in and day out to prove that they were exposed to herbicides just like boots on the ground in Vietnam. And they were. We know for a fact they were. There was lots of evidence there were. There was a VA internal document saying they were. VA issued a training letter saying, hey, these veterans were likely exposed to herbicide use at air bases in Thailand. And we finally had M21 provisions, VA internal adjudication manual, giving guidance to the AOJ and to others at VA about how to adjudicate these Thailand claims. But they just weren't granting it. And so if you went to the board, it was completely scattershot whether you were going to get a VLJ who, one, knew about all these provisions,
Right. Yep.
and two, agreed with them, we had some VLJs that completely got it. They understood the training letter. They understood the evidence. They understood what arguments we were making, showing, Mr. Veteran was in flight control and on the flight line of this Royal Thai Air Force Base directly next to the perimeter and saw people spraying daily and now has all these conditions that are historically presumptively due to herbicide agents. Please grant service connection. Some people really got it. And then you had VLJs who just flat out refused to acknowledge that there was even evidence of herbicide use at Thailand, and just even would go so far as to tell the veteran, you're incredible because you claimed this. There's no provision in VA law saying this is true. So if we'd had that back then, that would have been great. And now we have the PACT Act. I struggle to think of how are we going to use this to efficiently help veterans with their claims. And I'm really frankly struggling to think of a good example of when I would want the chairman to have this authority.
And, a piece of this is really, we want veterans to have control of their own destiny for their own case.
Yes.
Simple concept, one would think, right?
Choice and control.
Choice and control. I don't know where I've heard that from before, but
VA.
So I think any provision that would grant this authority has to come with the veteran's ability to opt out.
Mm-hmm.
Otherwise, you are forcing veterans to have their case decided alongside and potentially get swept up with other veterans' claims. Because to be clear, what we're talking about here in this proposal, which again is not law, but it would allow VA to determine if there are common issues of law or fact between different veterans' cases that are pending at the board and adjudicate them collectively. Now, yes, each veteran would be entitled to their own decision, but there are a lot of veterans that might not want their case to be collectively decided with a bunch of other veterans' cases who are pending.
Right.
And so, an example I can think of is, and, we see this quite frequently, is there's a question about the validity of a particular VA exam. And we're making an argument, not a factual argument, but there's something maybe fundamentally incorrect about the exam that could potentially affect a number of different veterans who all have cases pending before the board.
Right.
We may make arguments that say, sure, the validity of the exam it's wrong. We would ideally like a new exam, but we don't need a new exam necessarily for you to still grant my case. And so we would, in that instance, probably want the board to not remand along with the other veterans' cases for a new exam based on a collective fallacy in how the exam was compiled. We want you to grant the veteran's case in this individual case. And so without a veteran's ability to opt out because they see how their case might individually benefit from particular legal arguments they're making, they don't have choice and control over their case. And so that's a big issue here. There's also just, the legislation, if you read it, the proposed legislation, if you read it, in my opinion, it's not clear at all about what the procedures would be on how to actually achieve this. And so the key is no veteran should be harmed by this. And until that is crystallized, it's difficult for us to, I think, say that this particular provision would be overall beneficial for veterans.
I agree. All right. The second piece that we're concerned and actively monitoring includes expanding jurisdiction for the Court of Appeals for Veterans Claims. So right now, the court can hear final decisions from the Board of Veterans Appeals. But this bill lets the CAVC review class actions, class certifications, which frankly, they can now.
Right.
Federal Circuit said they can review class actions, and there's a number that have been filed. CCK just filed one recently, along with our colleagues at NVLSP. So check out our press release on that if you're interested. But fine with that. Class actions, that ship sailed. We know the CAVC can do that. But the other thing it allows for is this sort of partial jurisdiction. So you can take a limited issue of fact or law up to the CAVC. They can review it and send a limited remand back to the agency to fix something, but retain jurisdiction. It just sort of, I think, frankly, makes it a procedural mess.
Yes.
CAVC is not set up to do this. The board is not set up to do this. And both, I think, have said they're not interested in doing this.
They have. And if you think the process is a little chaotic now, or if the court's docket is overburdened now, just wait until they have the ability or requirement, perhaps, to review non-final VA decisions, like supplemental claims. And so this, in my view here, it creates an overlapping and confusing jurisdictional procedural lay of the land for veterans, especially veterans who aren't represented, to have to navigate through.
Right.
The AMA system, the appeals modernization system, the new VA procedural system has only been in effect since 2019. And so not even 10 years yet. So this really throws a wrinkle into the procedural aspects of working a case. And it's unclear, it's really unworkable, but it's unclear to me how this would even work without, like I said, burdening the court or creating a situation that veterans could easily navigate.
Well, the other thing is you have to remember that when you're before VA, so the regional office or the board, it is supposed to be, and it might not always feel that way, but it is non-adversarial.
Yep.
There are no two parties on either side. The VA is not against you. They are supposed to be helping you through the process and help you with your claim. It's supposed to be veteran-friendly,
Yes.
non-adversarial. There's no one fighting against you. When you get to the court, it is the first time, it is adversarial. It is absolutely adversarial. It's a regular legal process. There is Office of General Counsel that represents VA and their interests. And then a veteran might be pro se by themselves, or they might have an attorney representing them. And so to have this jump back and forth from an adversarial to a non-adversarial system with these limited remands will be confusing for veterans and advocates. So I think that it's just, like you said, muddied. The other thing that off the top of my head, I know the CAVC is at a record number of appeals this year. And so this would only increase that process without adding additional resources to the CAVC. So I really struggle to see how that would work.
And there's a natural vetting that is supposed to happen. I'm not saying it happens all the time, but there's a natural vetting process that happens in a veteran's case, whereby they file a claim at the regional office, they may have to appeal. They have to appeal a few times. They go to the board. They're adding evidence. They're adding legal arguments. And then the way the system works now is once a case reaches the Court of Appeals, we're really looking at briefing a very, definitive legal issue. We're not looking at the case necessarily, where we're looking at every potential issue that has come up in the case. Think of it like, the tip of a pyramid, if you will.
Yeah, it's a funnel.
It's a funnel, absolutely. And so there's a certain efficiency that comes with that. And I think that benefits veterans overall, forcing the court to look at a particular legal issue and dealing with that legal issue. Whereas if now they're forced to, in addition to that, adjudicate non-final decisions, I view that as being, as you said, muddying the waters in a way that is not beneficial at all.
Agreed. So we think that some parts of the bill are promising. We talked about how we support improved tracking and data reporting and transparency into what VA is up to, what's happening with remands, what's happening with appeals. We like that. We like more information for our clients and our viewers. But we have concerns about efficiencies overriding fairness. Would not support this bill unless it has opt-out provisions for veterans to not participate in aggregate action. We want to avoid overloading the CAVC. Right now, the whole adjudication process at the CAVC, it's not lightning fast, but it certainly is quicker than going through the appeal process to the board. And so I would really be, I would loathe to see the court burdened where veterans were waiting years to get a decision from the CAVC. And we just have to safeguard veterans' rights, make sure that each individual case gets its due time and each veteran gets to be heard on their individual matters. So for more detail, be sure to check out our blog post that we have about this particular issue. And as updates come in, we'll be sure to let you know.